This is Agriculture Today. We are back now with a timely segment, being that this past week we had a recent Supreme Court ruling on a case which is titled West Virginia versus the Environmental Protection Agency, otherwise known as the EPA. And to comment on this recent ruling, we have, of course, K-State University and Washburn University School of Law's Roger McEowen. So, Roger, thank you for joining us.
Good to be with you, Samantha.
Absolutely. So like I mentioned, we're going to be talking about the West Virginia versus EPA recent Supreme Court ruling. So how did this case get brought about, and what's some of the background we should know about this case?
Well, the case arose out of the Obama administration's Clean Power Plan, which would have required states to reduce emissions from the generation of electricity, mostly by moving away from coal-fired plants and towards sustainable or what are viewed as sustainable energy sources. And some people may remember President Obama stating early in his administration that he was going to basically put coal power plants out of business. The way he was going to do that was to delegate the authority to the Environmental Protection Agency, the EPA, to come up with a rule that would accomplish that. That's what the Clean Power Plan was all about. Well, it never went into effect because the U.S. Supreme Court blocked it back in 2016 by entering an injunction. And then when President Trump was elected, the Trump administration repealed the Clean Power Plan, arguing that the federal government shouldn't take such an active role in reducing carbon emissions. And 21 states, including West Virginia, which was the lead state, the named plaintiff in this litigation, sued the EPA, urging the court to reject the Trump plan, and the case went through the federal courts until it reached the U.S. Supreme Court, which agreed to take the case and heard oral arguments in it, and oral arguments occurred in February of this year.
And now that we've gotten this ruling, we've really heard that the Supreme Court has pretty much wiped the slate clean. Is that correct?
Yeah, the crux of the debate in this case concerns something called the Major Questions Doctrine, and this idea has been debated by judges over the past 20 years or so. And the idea is that the executive branch actions that have vast economic or political significance should face an extra high hurdle to win a court's approval. And in those cases, the agencies would need explicit authority from Congress for the actions that they're taking. The Supreme Court, in wiping out the EPA's attempt to regulate greenhouse gas emissions, said that the Congress never delegated to the EPA the regulatory authority to do so. And this goes back to that Clean Power Plan. And let me go back and discuss a little bit further the setup in this case. Of course, the court stayed, as I said earlier, the Clean Power Plan back in 2016, and what the agency was doing there really was a three-step approach to regulate coal-fired plants, electricity-generating plants. And in this opinion, the court is saying that steps 2 and 3 of those building blocks the EPA could not do. To boil down about 85 pages of the court opinion, what the court is saying is, EPA, you can regulate to require equipment upgrades at coal-fired powered electricity generating plants, and you can regulate in a way that requires them to improve their operating practices. But you cannot regulate to require a shift in the manner of energy production, which is what the second and third prongs or building blocks in that Clean Power Plan would have done. And the government projected, the EPA projected that it would be imposing billions of dollars in compliance costs. It would raise substantially electricity prices. It would require the requirement of dozens of coal plants, and eliminate it would retire, I should say, dozens of coal plants, put them out of business, and eliminate tens of thousands of jobs. So when you get what the court said in their opinion yesterday, to boil it down, is when you have that extensive a regulation that has that type of an economic impact on the country, that is something that is to be done by the Congress. That is not to be left up to an unelected bureaucratic agency such as the EPA. They do not have authority to do that. So this is really a big deal. It is the Major Questions Doctrine is an exception to what we call Chevron Deference. And what that is, Samantha, is when The Congress creates a very generic law and then delegates to the administrative agency to write the rules, to fill in the blanks, to carry out the policy of the law that the Congress has enacted, that the agency can do so, and you can only challenge those regulations successfully if the agency is deemed to have acted in an arbitrary and capricious manner. That is a very low threshold to clear. That's known as giving great deference to the agency to do whatever they need to do to carry out the general policy of the statute enacted by the Congress. That's what we call Chevron Deference, named after the court case. What this major questions doctrine is an exception to that the court has created over the last 20 years. And they say, okay, you've got deference, but the Congress does not delegate to an administrative agency those things that have a dramatic impact on the overall economy. In other words, you can't set a policy change in place at the administrative level. If the Congress wants to use different sources of energy production, such as wind and solar, the Congress has to specifically specify that in a statute. Agencies can't come up with it on their own. That's really what this case is all about.
So you mentioned plural agencies here, and I think that's a key part of this, is that the EPA isn't the only government agency that has tried to put regulations like this in place. So can we expect to see other governmental agencies affected by this ruling?
I do, and I think this opinion has that type of reach to it also. And we think of other agencies that agriculture is regulated by, of course, the USDA and wetlands regulation, the Swamp Buster under the USDA, wetland regulation under the Corps of Engineers and the EPA. That impacts agriculture. You get out west, you have grazing programs regulated by the Bureau of Land Management. And all of those, when you have an agency that writes a rule that really has a legal impact of changing a policy, they're not going to be able to do that under the Supreme Court's opinion. So I think the case has serious potential implications for agriculture in general, and does set the stage for further limitations on other administrative agencies such as the USDA and the FSA, that in the absence of explicit congressional authorization for the regulation in question, they're going to see challenges to their authority anytime they seek to resolve a major question. Now, obviously, the issue is going to be whether what something is that's being done invokes the major question doctrine or not, and that's kind of an issue in and of itself. But I think it does send a message to the regulatory agencies at the federal level that you better not go too far, because you're not going to be granted the deference that you normally are used to and have been used to for the past 40 to 50 years.
Sure, and that shift of power in this way will be interesting to see how it plays out, because really it's taking that power away from the agencies, not away from them, but not as strongly in their hands as before, and it's giving it to Congress, right, which is, a voted upon body by the people.
That is correct, and the majority, the six-justice majority, cited a lot of documents by the founding fathers of this country, the Federalist Papers written largely by Alexander Hamilton, in saying that this country is run by elected representatives, not bureaucrats that are unelected and could serve necessarily for life. So, as they did in the abortion decision a few days ago, they've done it in this instance. They said this is to be left up to the people. The states have more power to set rules. If it is the abortion situation, they're saying we don't have any involvement in that issue. That's a states' right issue. That power is reserved to the states under the 10th Amendment. Now here they've said, when you're trying to change major policy decisions are to be made by elected representatives. That rests with the Congress. So they're not saying you can't regulate. They're just saying when you get into a major issue, a major question, Congress, you've got to do your job. So they kicked this back to Congress and basically said, Congress, you want to do that? That's fine. You're accountable to the voters if the voters don't like it. Bureaucrats are not, and that's the way our system is supposed to work.
Sure, and if listeners are tuning in and they're thinking they want to understand more about this ruling and find more information on it and how it might affect different regulations that are already in place, where can they find that at?
I will have something coming out on this soon in the next few days. This is a brand new opinion, and it's rather lengthy, and it's going to take some time to write something on this. But I will have something posted to my website that can be accessed through the homepage, or on my blog that can be accessed through the homepage of my website, which is washburnlaw.edu/Walter, WALTR.
Absolutely. And as always, that'll be linked in today's show notes, which can be found on agtoday.net. But of course, as always, we thank you, Roger, for your time, and thank you for your insight.
Thank you, Samantha.
Absolutely. That was K-State and Washburn University School of Law's Roger McEowen covering the latest Supreme Court ruling on the West Virginia versus the EPA case.